In M&A transactions, it is common for M&A buyers to expect sellers to furnish non-compete undertakings and not compete with the business they have transferred to the buyer. However, the fundamental question is, under Indian laws, are such non-compete restrictions valid or not? Well, Indian Contract Act 1872 states that if a non-compete restriction is reasonable in nature and the business which has been transferred by the seller to the buyer has been transferred along with its goodwill, then such non-compete restrictions can be enforced. Now, insofar as the reasonableness test is concerned, that depends on a variety of factors, including the scope of the restriction, the nature, the duration, geographical limits, etc., to determine if a restriction is reasonable or not. Equally, insofar as the goodwill is concerned, it is imperative that the business transfer document categorically spells out that goodwill of the business has been transferred to this buyer by the seller. Insofar as share transfers are concerned, Indian courts have held that if the entire shareholding of a company is transferred, that tantamounts to transfer of a business with goodwill, and therefore non-compete restrictions, provided they are reasonable, can be enforced. It remains a grey area whether in a part transfer of shares this construct can be extended or not, and needs to be carefully evaluated. From a competition law standpoint, it is very critical if there is a strategic M&A happening or there is a one competitor acquiring shares for another competitor, that again the geographical limits, the overall boundaries of the non-compete restrictions are carefully defined so that it does not transgress the competition law rules and regulations. In summary, these are very, very intricate constructs and needs expert advice, and really needs to be carefully defined so that these contracts can be enforced after the completion of a M&A transaction. I hope you found this video useful. Thank you very much for watching this.